Is there a time limit for enforcing my trademarks? I'm Angela Langlotz, trademark and copyright attorney. I go live here to answer your trademark and copyright questions. If you have questions, drop them into the comments below. I'll answer them on a future live. So somebody wants to know, is there a time limit for enforcing my trademark? Well, interestingly, the federal trademark law, it's called the Lanham Act, doesn't have a set statute of limitations. The statute of limitations is the deadline by which you must bring a certain legal claim. The Lanham Act doesn't specify. So how do courts decide? Well, they generally look at similar claims in state courts and then use that statute of limitations to decide how soon a trademark, an infringed trademark owner, how soon they have to bring suit. That seems to be generally about 4 years. So should you wait 4 years to bring suit or to complain about someone else's trademark infringement? No, absolutely not. You should address any claims of trademark infringement as soon as you discover them. Why? Because your infringer may not know that you're out there. It may be a completely innocent infringement, and the sooner you tell them, hey, this is my trademark, I would like you to stop infringing it, please, the sooner you ask them to stop infringing, the less entrenched they are in using your trademark. If you let the trademark infringement go on and decide that you don't want to be mean and ask them to stop, the longer they use the trademark, the more invested in that trademark use they are, and the harder it's going to be to get them to stop. So I don't recommend that you wait when you discover a trademark infringer. So how does the enforcement process look? Generally speaking, we send the trademark infringer a cease and desist letter, and we attach a copy of the trademark registration to the letter and explain why their behavior infringes and tell them what's going to happen if they continue infringing. That what's going to happen if they continue infringing can include things like triple damages for willful trademark infringement, the disgorgement, that means the giving up of all of the profits that they gained from their naughty trademark infringing behavior. Things like that are powerful deterrents to trademark infringement because it sets out pretty plainly what's going to happen, what the consequences will be if the infringement doesn't stop. What if you don't have a trademark registration? Well, if you don't have a trademark registration, but you have some common law trademark rights, you really need to see a trademark attorney. Why? Because you don't want to send a cease and desist letter if you're not the first user of the trademark. That could cause some really interesting backlash when your infringer tells you, hey, as a matter of fact, I've been using the mark longer than you have, and I want you to cease and desist. As a general rule, I don't advise engaging in any trademark enforcement without first consulting a trademark attorney. We know what the rules are, and we know the best way to combat various infringements. One of the most important things is to make sure that your trademark rights are actually better than those of the person whom you're accusing of infringement. If you're a junior user or there's some other weird complication, I won't go into that here, you can find yourself basically being told by the infringer to stop. So you want to make sure that you have the best trademark rights before you start any infringement proceedings. Do we just sue them? Well, no, most of the time that's not necessary, especially if you have a trademark registration. If you have a trademark registration, your enforcement is pretty straightforward. You have these rights. The rights are listed on the trademark certificate. In other words, it says what trademark you own, the goods and services that you own that registration for, and it includes your date of first use. So these are things that you don't need to prove to the infringer. It's already all there on the trademark certificate. So it's hard for the infringer to argue about those things, about those facts. If you need to take the infringer to court, the fact that you have a trademark certificate with your rights clearly documented is conclusive, actually not conclusive, presumptive. We'll say that there is a presumption that all of those things are correct. And if your infringer wants to allege otherwise, yes, they can do that, but they're going to have to come up with a whole bunch of proof in order to prove that your rights are not what they say they are on the trademark certificate. That sort of proof involves money. So by having a trademark certificate, you're making it harder for your infringers to allege that you don't have superior rights because it's already printed on the trademark certificate. You're in a much better position to enforce your trademark rights if you have a trademark registration. If you don't have a registration and you're relying on your common law trademark rights, the only thing that you can say is a pretty wimpy, hey, I was using that first, please stop. And your infringer probably isn't going to give those claims much credence. Why? Because you don't have any proof. You don't have any proof that you're the owner of the trademark. You don't have any proof of when you started using it. You don't have any proof about how long you've been using it or on what goods or anything like that. You just have you saying that you were using it first. That's not terribly convincing. So having this proof on the trademark certificate can be a powerful deterrent to any continued infringement by your naughty infringer. The federal trademark certificate also means that the trademark office, because your trademark rights are on the trademark database, they will refuse to register. So the trademark examiner will refuse to register any marks that are confusingly similar to yours. What's confusingly similar? Well, it depends on what your goods and services are, but anything that would confuse the consumer into thinking that Party A and Party B are the same person, that's going to be considered confusingly similar, and such marks will be refused by the Patent and Trademark Office when they're applied for. So, in essence, your trademark registration gets you a sort of trademark watchdog at the trademark office, in that the examiners will refuse to register confusingly similar trademarks that may infringe your existing trademark rights. The bottom line is, if you would like trademark rights that you can actually enforce, you need to get a federal trademark registration. That federal trademark registration is presumptive proof that you have the best rights to that trademark. I'm Angela Langlotz. I go live here on weekdays to discuss trademarks and copyrights. If you have trademark and copyright questions, drop them into the comments below. I'll answer them, just like I am this one, on a future live video. Don't forget to like and subscribe to get all of my newest material.